Welcome to GameChanger Law Advisors, Simplifying the Law series. Now, I'm sure at some point in the course of running your business, you'd have thought of entering into a contract or an arrangement with a person or an entity that is connected to your business in some manner. Ever wondered what the compliance requirements may be? Well, there is a term for this under the Companies Act, related party transactions. In part 1 of this series, we will tell you a little bit more about who is a related party. Section 2, subsection 76, read with section 188 of the Companies Act 2013, discusses the concept of related party transactions. A related party could either be an individual or a corporate entity. The types of individuals who are considered as related parties with reference to a company, and let's say for simplicity, company X, could be 1. Director of company X or his or her relative. 2. A key managerial person of company X or his or her relative. Or 3. Any person who the director or manager of company X regularly takes advice, directions or instructions from in order to perform his or her duties. An exception here is that if such advice were given in a professional capacity, for example, a lawyer or accountant, such person would not be considered a related party. The types of corporate entities who are considered as related parties with reference to company X are 1. Group companies. For example, parent company of company X or a subsidiary of company X. The second type of corporate entity that could be a related party of company X is a firm, a partnership or LLP in which the director or manager of company X or his or her relative is a partner. The third type of corporate entity could be another private limited company where the director or manager of company X is a member, that is a shareholder, or a director. The fourth type of corporate entity that could be a related party of company X is a public company in which the director or manager holds, along with his or her relative, more than 2% of that public company's paid up capital. And last, a related party could also be a body corporate whose board of directors, managing director or manager takes advice, directions or instructions from the director or manager of company X in order to perform his or her duties. Again, an exception here is that if such advice were given in a professional capacity, such a body corporate would not be considered a related party. That's it for part 1 of GameChanger Law Advisors, Simplifying the Law series, Related Party Transactions. In part 2, we'll find out what types of transactions are regarded as related party transactions.